Consequences of non-appearance of the complainant. In criminal cases instituted upon a complaint, the complainant plays a vital role in prosecuting the case before the court. Since the proceedings are initiated at the instance of the complainant, his presence is generally necessary during the trial. However, situations may arise where the complainant fails to appear before the court on the date fixed for hearing. To deal with such circumstances, the law prescribes specific consequences under the BNSS 2023. The object of this provision is to ensure that criminal proceedings are not unnecessarily prolonged due to the negligence or lack of interest of the complainant. At the same time, the law gives discretion to the magistrate to protect the interests of justice in appropriate cases. Legal provision. The provisions relating to the non appearance of the complainant are contained in Section 279 of the BNSS 2023, which is corresponding to Section 256 of CRPC 1973. Section 279 provides that where a summons has been issued on a complaint and the complainant fails to appear on the date fixed for hearing or on any subsequent date to which the case has been adjourned. The magistrate shall acquit the accused unless there are sufficient reasons to adjourn the hearing. Object of the provision. The main objectives of the section 279 of BNSS 2023 are to prevent unnecessary harassment of the accused, to ensure diligent prosecution of complaint cases, to discourage frivolous or irresponsible litigation, to save valuable judicial time, to promote speedy disposal of criminal cases. Consequences of non appearance, acquittal of the accused. The general rule under Section 279 is that if the complainant remains absent on the date fixed for hearing, the magistrate shall acquit the accused. This provision recognizes that if the complainant himself is not interested in pursuing the complaint, there is little justification for compelling the accused to continue facing criminal proceedings. Discretion of the magistrate to adjourn the case. The magistrate is not bound to acquit the accused in every case of absence. The section gives discretion to the court to adjourn the hearing if sufficient reasons exist. For example, where the complainant is unable to attend due to illness, accident, unavoidable circumstances, or any other valid reason, the magistrate may postpone the proceedings to another date. Representation through pleader. The proviso to Section 279 recognizes that the complainant may not always be required to appear personally before the court. Where the complainant is represented by an advocate or pleader, the magistrate may dispense with the complainant's personal attendance and proceed with the case. In such circumstances, the absence of the complainant does not necessarily result in acquittal of the accused. Representation by prosecuting officer. The magistrate may also proceed with the case where the complainant is represented by the officer conducting the prosecution. This exception ensures that the administration of justice is not obstructed merely because the complainant is personally absent. Personal attendance not necessary. If the magistrate is not of the opinion that the personal attendance of the complainant is not essential for the progress of the case, he may exempt the complainant from appearing and continue the proceedings. This provision reflects the practical reality that personal attendance may not be required at every stage of the trial. Effect of death of the complainant. Section 279(2) of BNSS 2023 extends the application of these provisions to cases where the complainant has died. The mere death of the complainant does not automatically terminate the proceedings. The magistrate must consider the circumstances of the case and decide whether the proceedings should continue or whether the accused should be acquitted. This provision prevents injustice in cases where sufficient evidence already exists and continuation of the proceedings is necessary for the end of justice. Judicial interpretation. Associated Cement Co. Limited versus Keshav Nand 1998 1 SCC 687. The Supreme Court held that the purpose of the provision is not to punish the complainant for his absence but to protect the accused from unnecessary harassment. The magistrate should exercise his discretion judicially and consider whether the complainant's presence is actually necessary on the particular date. Muhammad Azim versus A. Venkatesh 2002 CRI LJ 1642. The court observed that acquittal should not be ordered mechanically merely because the complainant is absent. The magistrate must examine whether the circumstances justify adjournment or continuation of proceedings. Importance or significance. The provision relating to non appearance of the complainant is important because it strikes a balance between the rights of the complainant and the rights of the accused. While it discourages negligence on the part of the complainant, it also grants the magistrate sufficient discretion to prevent miscarriage of justice. The provision promotes judicial efficiency, protects accused persons from unnecessary prosecution, and ensures that criminal proceedings are conducted responsibly and diligently. Conclusion. The consequences of non appearance of the complainant are governed by Section 279 of the BNSS 2023. Ordinarily, the absence of the complainant results in the acquittal of the accused. However, the magistrate may adjourn the case or proceed with the trial where the complainant is represented or where his personal attendance is not necessary. The provision seeks to ensure fairness, prevent abuse of process, and promote the efficient administration of criminal justice.